You had the EPA's endangerment finding on greenhouse gases, which never should have been an aspect of the law, but had a bad Supreme Court 5-4 Supreme Court decision underpinning it that the EPA put in place in 2010, which allowed the Obama administration to just basically go crazy in its efforts to kill coal, and then to start moving on natural gas and oil as well later in his second term. And then you also had the second big pillar, which was the Chevron deference, this principle of the judiciary that ordered judges, federal judges, said they had to defer to the judgment of the regulators on matters of interpreting our major environmental statutes, like the Clean Air Act and the Clean Water Act and the Endangered Species Act and all these big, major pieces of legislation, climate environmental protection legislation that came into place in the 1970s that really have gone a long way to cleaning up the air and water in our country and protecting a lot of important species like bald eagles and grizzly bears and gray wolves. But now, of course, eventually came to be systematically abused by the left-wing environmental organizations, activists, and had really kind of been expanded grossly beyond their original intent by the regulatory agencies. So you did away with the Chevron deference in a case called Loper Bright v. Raimondo in 2024, in the summer of 2024, and you rescinded the endangerment finding at the EPA late last year.